Looks like we have some attendees joining in. Great.
Okay. Just let me know when you want to start, Robert, so I can.
Sure. Well, we'll give a few minutes for the stragglers to join in, and
Sure.
maybe another minute.
Right.
Always the case that people have issues logging into these things, and sometimes makes them straggle a little bit coming in.
Mm-hmm.
It's like we have a great group of people from all over the world joining in, which is amazing.
Oh, great. Good to hear.
It's like a mixture of direct applicants, patent people, trademark people. Got people joining from Mexico, USA, I think Switzerland, UK, Brazil, all over the world.
Great.
Well, let's get started then.
Sounds good. Good morning, everyone. Thank you for joining us. Today we are working to present an overview of the IP landscape and the main differences between how IP operates in the US and Canada. This webinar is hosted by Patentarea and Brunet Co. And first of all, thank you so much, Robert and Mauricio, for inviting me to be your moderator today. I'm speaking, but I'm also moderating, and we're joined here just to introduce myself. My name is Barbara Johnson, although my name it's a little different. It became a little Norwegian this morning. But I'm the Associate General Counsel at the Better Business Bureau here in the US, but we also work, the association also operates in Canada. I'm an attorney, I'm a trademark attorney here in the US, but as a background, I'm Brazilian. I've worked in Brazil for years, so for any, Brazilian attendees, bom dia. And I lead the IP strategy at the BBB with a little bit of AI, trust, innovation, and everything related mostly to trademarks. Talking about our speakers here, Robert's the founder of Brunet Co. He's one of the leading Canadian practitioners, huge expertise in research development, especially in the patent side, and he handles numerous US and international patents. And he specialized in corporate and IP strategy, transactional due diligence, in-house IP portfolios, and patent prosecution, both in Canada but also internationally. He's registered to practice before the CIPO and the PTO here in the US, and he's a member of the IP Institute of Canada, INTA or INTA. There's a debate about that, and the NPPI. And Mauricio, he's a senior patent specialist at Patentarea, where he supports companies, law firms, and inventors in successfully filing patent applications worldwide. He has a huge expertise in international patent procedure, and also delivers tailored guidance to help clients protect their innovations across all jurisdictions. We are obviously talking about the IP landscape, but as you can see, our speakers here, they are mainly those masters in patent law. So basically, I am going to talk a little about trademark because we do need to give an overview of all types of IP, but our webinar today is mostly about patents. But obviously, if you have any questions, I know you can always reach out to me, to Robert's office, and also to Mauricio, so we can find the best support for your questions. But just a little overview, I'm going to start talk a little bit. I'm just going to ask everybody to mute your mics. Just to give a little overview on IP, I always like, every time I give a class on IP, I like to speak a little of, let's imagine an airplane, right? So the patent is basically everything that's going to make this plane works. So how are we going to fly that? The industrial design is how it's going to look. The trademark is, you know, what we're gonna see. So if you want to fly Delta or United, that's what we're talking about. And the copyright, which is not exactly related to the plane, but it's gonna be, for example, the ads, you know, everything that they put in the marketplace to make the consumer like them. And this is actually my jam. So to talk a little bit about trademark, the trademark is what provides exclusive rights to a sign that makes it distinctive. So here at the BBB, we work with something that our mission is related, for example, to consumer trust. So how do we make a consumer to trust a business, right? They use the BBB sign. So I always like to use this example to make it easier to understand how trademarks operate. Um, Different than patents, you can renew or trademarks. Obviously, there are some requirements for that, but you know, in a perfect world, you can renew those trademarks indefinitely. Different than a patent, which is going to be in the public domain in a couple of years. But providing that you fulfill all the requirements, you can have this trademark um, indefinitely. And a few considerations, especially here in the US, because the US is a very peculiar place when it comes to IP. The trademarks, yes, they can be filed after they are already used in commerce. Obviously, this is not something that we would recommend. And if you, for example, if you're thinking of using a trademark in the future, you can obviously file this as an intent to use with the reminder that you're going to need to prove the use and when it comes to the time for the registration and after that. But you can actually file after using. There's no novelty like it will be in a patent, right? They need to be unique. They cannot be confusingly similar to other ones in your with same goods and services. And also here in the US, differently than in Canada, we do have a special route for trademarks that with time acquired distinctiveness. There is a protection in the Lanham Act that actually allows it to happen. And in terms of priority, if you have a foreign trademark, you can claim priority within the last 6 months, both in the US and Canada. Also, about the filing specs, there is a date of first use that you must have and you must document it when you are in the US. So it's always good to have it documented with your team. If, for example, you launched your Instagram page and that's the very first time that you use your mark, have a PDF of that, have a date. The USPTO loves that. And in terms of filing in one single filing internationally, both the US and Canada, they are signers of the Madrid system. And here's an overview because Brazil signed this like in 2019. So it's not something that's, it just became very broad a few years ago. So there is this possibility of making one single filing for different countries. The US and Canada, this is possible, but always reminding that the filing is making one single application, but each country will have their requirements to process the trademark. So for example, you can file here in the US for a trademark here in Brazil and in Canada, but Canada and the US can register the trademark, but you can still have problems with the trademark in Brazil because it needs to fulfill the requirements there to have registered there. So, and one last thing that I didn't put, but it's very, very important when it comes to filing a trademark in the US. If you're a foreign company, you do need a US trademark attorney with a bar number, and of course in good standing to protect your mark. Here, actually, Robert brought us a few examples of how the trademark can identify and bring you consumer trust. And as I was saying, I brought the BBB one as an example to showcase the trademark is basically the relationship that you have with, the good and the service itself. It's the very first thing that you see when it comes to a product or a good. So if if you want to drink something, if you want to drink a nice soda, you're going to reach out for Coca-Cola, or if you want to have your business accredited, you're going to look for the BBB. I will now finish my trademark part and give the floor to Mauricio for the patents overview.
Yeah, thank you so much, Barbara. Thank you so much for the introduction. Also, just to let you guys know, at patentarea.com, first of all, we're part of the marcaria.com network, the same folks who've been leading name and trademark and domain registrations for years now. And now, just to be clear, we're not a law firm. Think of us as a backstage crew that keeps the show running smoothly for our networks of attorneys. While they focus on heavy duty legal work, we handle everything that makes the job easier, gathering the right documents, answering the client questions about procedures and fees, and taking care of the admin side so nothing slows down the process. And here's where we really shine. If your project crosses borders, we make coordinating filing in multiple countries a whole lot easier, along with the prosecutions as well. We're talking about turning what could be a tangled international maze into a clear, consistent, and well-guided process for both the clients and attorneys alike. And so, with respect to the slide here, patents overview, um, and well, patent applications must be filed in each separate country. That's correct, because patents are territorial. So meaning that if you were to file your first application in the United States, it wouldn't necessarily be a worldwide patent. Your patent application would only be protected in the United States first and foremost. And and with respect to the first to file system, in today's patent system, rights are awarded on a first to file basis, which means that the first person to file a patent application for an invention is one who secures the rights. Even if someone invented it earlier, because of this, it's very important to file quickly, even if only a provisional application at the start, so that you lock in your priority date before anyone else files something similar. Um, and with respect to when the examinations occur under legal rules of in the individual countries, yes. As an example, once you file your patent application in the United States, you would pay for the examination fees together with the application, and thereafterwards you would have a patent pending processed or filing receipt indicating that your patent is pending, although it's not a legally how can I say it it is a legally binding document in terms of a filing receipt. However, if someone were to copy your idea within the time period from when you filed the application till it's granted, you can't really claim any priority rights until you actually have the patent certificate in hand. So it's very important that you see the process through, and that the process at the very start is correctly in terms of writing the patent specifications are correctly written in terms of international standards. So, with respect to that, we can also, as we'll get into the slides as we go on here, we can accelerate examination. So that way, it could be various types of strategies that we can implement in terms of how we can help you in terms of to put you on the correct track to have your application granted as soon as possible, rather than waiting 24 or excuse me 18 to 24 months down the line. And with respect to the filing routes, we can file via the Paris Convention, which is, as an example, say if you were to file your application today in the United States on the 27th of October, we would then have 12 months from the first filing date to claim priority of that first filed application, and any country that you want to be able to protect your invention in. So having that information on the outset, it's very important in terms of how to set up your patent strategy, and to have a successful patent strategy in place. And it also depends on your budget as well, because if you need to have time extended from 12 months, we can do so by filing what is called an international PCT application, which is the Patent Cooperation Treaty PCT system. And that vehicle would extend from claiming priority from 12 months to 30 or 31 months, depending upon the country that you need to file your patent in. And this international PCT application is not a worldwide patent. It doesn't cover the entire world. It's just a vehicle only to be used to extend time to help inventors pull money together to accumulate their budget over time to then file in different countries in which they need to file it in. So it's also a very important vehicle to use and to know how that system works as well.
Just trying to, oops.
Yeah.
Thank you, Mauricio. Robert, why don't you start with the jurisdictional differences?
Great. Well, thanks to both of you for helping put together this webinar, and thanks to everybody who's joined us. I'd like to, really focus on what the differences are between the US and Canada. I am a Canadian patent agent registered to practice in the Canadian Intellectual Property Office, but also in the US Patent and Trademark Office. And I practice in the US only for Canadian clients, so not for foreign clients, but the vast majority of our patent prosecution takes place in the US before it takes place in Canada. So we're very familiar with the rules on both sides of the border. And in this talk, I think I'd really like to focus on 10 topics that are the major sources of differences between the two systems. And this will come up during the course of the presentation, but those differences are patentable subject matter, foreign filing licenses, claim fees, examination differences in terms of both how you obtain examination and how it is conducted by the two patent offices, continuation and divisional practice, which is a significant source of variation, restrictions because of, let's say, unity of invention, accelerated examination options, and also obviousness type double patenting, maintenance fees, and patent term adjustments. So these are all, let's say, the major sources of differences in the two systems. And focusing in on this slide, the patentable subject matter differences can be significant. In many cases, they're the same. So generally speaking, the courts have said that in order for something to be patentable subject matter, it has to be an invention made by man. That's how they said it at the time, but made by a human being. So in other words, you cannot patent natural phenomena. You cannot patent algorithms, things that are merely abstract processes. So I'd like to give the example, if Sir Isaac Newton were seeking a patent for gravity when the apple fell on his head, that would not work. But if he patented a machine that uses gravity to move a weight and cause work to be done, that's the kind of thing that would be patentable. And so where we get differences in patentable subject matter between Canada and the US, one major one that we run into is methods of medical treatment. So let's say, surgical procedure would be patentable subject matter in the United States, but not patentable subject matter in Canada or Europe or any other country for that matter. So the US is rather unique in that methods of treatment are patentable. And so, when we look at treatment methods, oftentimes a US application will claim, let's say, a method of treating disease X by administering compound Y. And it will set out a series of steps in the administration of the compound that are performed by a physician. So the target of that method is the practitioner who is prescribing the drug or doing the surgical procedure. So in Canada, we would take that claim and we would rewrite that claim. And the claim would say use of compound Y in the treatment of disease X. So in other words, you flip the focus of the claim to how the compound is used. So it's compound related rather than the physical steps being performed by the practitioner. So that's a fairly major difference that we run into, particularly in the pharmaceutical space. Higher life forms is another very interesting one. So in the United States, there was a case called the Harvard mouse. And the Harvard mouse was a mouse that was genetically engineered to develop cancer. And this was useful because when you want to test chemotherapy drugs and cancer treating drugs, you need a live specimen that you know is going to reliably develop cancer. Otherwise, you may be testing the drug on a whole bunch of healthy, normal mice. And so that mouse was patentable in the United States, but not in Canada. And we can patent in Canada cell lines that are in the mouse. We can patent genetically engineered cell lines. We can patent sequences, all of that stuff, but not the mouse itself. And I think that is a fairly consistent guidance across a number of other jurisdictions as well. And then business methods. This is another area where the US differs significantly from other countries. Business methods are things like, classically things that are embodied in software, but not necessarily so. So for example, in the US, in order for a business method to be patentable, and this is a complicated area, but the machine or transformation test is kind of the fundamental thing you're looking at. So if the method is implemented by a machine or causes a transformation of matter, let's say in a chemical process, then that method may be patentable. And so if we take, say, the difference between a method and an algorithm, let's say you have cruise control in a car, you have adaptive cruise, and the car is using sensors to measure the distance to the car in front, and based on the rate of change of distance, it's varying the speed of the car in order to maintain a set distance between your car and the car ahead. As an algorithm, as a piece of code, that is not patentable, but as a method that is implemented by a machine that has an effect on something physical, then that method is patentable. And so you can patent that, let's say, not the code itself, but you can patent the method by which the processor is gathering the information, calculating something, and causing an effect on the car. And so in Canada, it's similar, but our guidance is that the method must be linked to an actual invention that has a physical existence or manifests a discernible physical effect or change. And so that's very similar to the machine or transformation test, but it really focuses on what is physical about the method. So that one of the other points that I mentioned in my overview that is a significant source of difference is a foreign filing license. So this is something that a lot of practitioners overlook. It's often, a forgotten detail, but in the United States, in order to file an application outside of the US, you first must file an application in the US. So the first filing has to be a US application. In other words, a US priority date. In Canada, there is no foreign filing license requirement. That means that in Canada, we can use a United States provisional application as the basis of our priority date or priority claim. And that first application is important because from there, all of the other applications obtain their first, their earliest priority date. In other words, all future citations of prior art are assessed versus that date. And so foreign filing license is an important requirement in a number of countries. For example, China, Italy, a number of countries have this foreign filing license requirement, but Canada did not, which allows us to use a US provisional application as the basis of our priority date. Next slide, please. So, when we speak about provisional applications, what is that? What are we talking about? Why is that? What distinction are we drawing between a provisional application and a non-provisional application? I will basically say that a provisional application in general is informal. And so what that means is that it doesn't have to have all the regular parts. It doesn't have to have formal drawings. It doesn't have to have claims even. It can be literally something scrawled on a cocktail napkin and filed. However, you only get the benefit of the priority date for the invention that is disclosed. So if you've done a shoddy job on preparing the provisional patent application, you really don't have strong support for that priority date. So if a piece of prior art and another application is filed with or published in the intervening 12 months between when you filed the provisional application and obtained your priority date and when you file your non-provisional application to go forward with all the requirements, and that piece of prior art has things in it that are important to your invention, and your provisional application doesn't have those things mentioned, then your provisional application is not going to prevent the citation of that later filed piece of art against your non-provisional application. So although it's often viewed as a let's say shortcut, or I hate the term quick and dirty, but that's the term that's used oftentimes, we really don't approach them that way. They need to be as similar in scope to what the final application will be in order to benefit from the priority date. And then, in Canada, we have a somewhat similar mechanism. Often it's billed as a similar mechanism called an incomplete application. But critically, that application is an irregular application. So in other words, it will get published. It will be something that you have to have a solid basis in the document to amend and add matter to. Any added matter that's not based in the original incomplete application won't be admissible. So it's really not at all the same thing, but it's often billed that way in the literature. And why as Canadians would we be interested in filing a US provisional application rather than a Canadian application? Well, one of the main reasons is that the patent term expiry date is calculated from the filing date of the non-provisional application. So when you file that provisional application, you have 12 months to file a non-provisional application. And that 12 months doesn't count against your patent term. Your patent term starts, let's say, 12 months later. So it's a pretty big advantage to gain an extra year of term. And that's one of the main reasons, actually, that we do it. And that and the fact that it's a relatively low cost filing fee. Mauricio, what has been your experience with provisional patent applications and people that are filing those, and what are their reasons?
Yeah. Well, I mean, based upon my experience in dealing with clients that are mostly interested in filing provisional applications, they're mostly interested in having or securing that early filing date, as you mentioned. However, once we have a client that approaches us here at Patentarea, what I like to do is I like to, meet with them, have a telephone call with them, or have a video conference call with them, and explain to them the intricacies of a provisional application. Although a lot of people like to say, you can have your provisional application written as informally as possible, but it's also very important to note that its value is only as strong as the disclosure inside of it. So, albeit, I always like to tell or inform our clients that we need to put everything in there and write it as properly as possible in order to have an elaborate patent that actually protects the scope of their invention, not informally, as you put it. But that's the way I like to position it in terms of, yes, it's also very cost inefficient. However, but it's also very important that in the U.S. law requires that the invention be described in enough detail that a person skilled in an art could understand it, reproduce it, and if the provisional application is vague or incomplete, we may lose the rights later on once we convert it to a non-provisional application, where the examiner reviews the application and says, hold on, there's something inconsistent here, or maybe we just added new material that in turn just voids the application altogether. So in that respect, it's also very important to note that once you do file a provisional application, that you do seek our expertise, or even an attorney's expertise in writing the actual non-provisional, or excuse me, provisional patent specifications when you put it together. So it's also very important to that. And also another point worth noting that's very important as well, there's no claim requirements. So claims are the most complex part of the patent. Since provisionals don't need them, drafting costs are then reduced because they're not needed. But we also want to be able to focus on having a clear and concise and broad patent specifications that are written at that stage. And there's no examination. The USPTO does not review or evaluate the provisionals, which keep the official fees very low. And you don't need to sign an oath or a declaration or prior art statement or formal formatting with respect to the actual way the application is drafted or presented. And so, yeah, I mean, in that respect, provisional applications do actually are very important to any inventor out there looking to secure the early filing date in that respect. Okay.
So how do you find that the provisional and non-provisional differ?
Well, in terms of how they differ, in at the end of the day, as I mentioned, where the claims are not mandatory and provisional, and having a well-written, detailed specification is far more important at the end of the day in terms of having that provisional application filed. And if we don't include the claims, we keep them broad and flexible. We don't rely on them alone. The disclosure itself must fully support later formal claims at a later stage once we cross that 12-month threshold to then convert it to a non-provisional application.
Well, I'd like to highlight, you know, some of the differences between Canada and US with non-provisional applications relate to the fees. So when in the United States, you get with your claims, with your filing fee, you get 3 independent claims and up to 20 total claims. So what does that mean? So an independent claim is kind of the core definition of what the invention is. It has all of the parts that you deem to be essential to put the invention, to protect the invention. And a dependent claim is a shorthand way of saying, so if I have claim 1, which is, let's say, the broadest statement of invention, and I want to add a feature to that claim, a shorthand way of doing that is saying claim 2, it says the invention according to claim 1, wherein, and then you add a feature. And so, in other words, cut and paste all of the features in claim 1 into claim 2. So why are these features important? Well, in order for infringement to be proven, each and every element of the claim needs to be in the infringing device or needs to be in the infringing accused subject matter. So if I have 5 features in claim 1 and I don't have a 6th feature, then claim 1 is, let's say, easier to catch someone who's an infringer. Why do I want to add an additional feature in claim 2? In other words, to make claim 2 narrower, because there may be a prior art citation from, let's say, a Chinese patent or some other patent that maybe was missed during the search process that has those 5 features, but it doesn't have the 6th feature. So claim 1 may fall in litigation and claim 2 would survive. And so that's why we filed independent claims and dependent claims. And I'm giving this at a level, you know, we have a range of expertise in the audience. Some people are practitioners, some people are applicants. And so we're trying to cover kind of a gamut of experience levels. But if you wish more detail on any particular topic, you can certainly ask a question by using the Q&A feature in the webinar, and Barbara will get those questions and she can take a look at them and ask them later towards the end of the presentation. And you know, I see one person has already asked a question, so that's great. Please feel free, go ahead and ask, and we'll get to them at the end of the presentation. So in Canada, we also have claim fees for up to 20 claims are covered with the initial filing fee. There's no limit on independent claims, so you could have 20 independent claims if you wanted. In Canada, we use multiple dependent claims, so we may say, claim 4 says the invention of any one of claims 1 through 3. In the United States, claim 4 would then count as 4 claims against your 20 total, because it would count according to claim 1, according to claim 2, according to claim 3, and according to claim 4. So that claim 4 would count for 4 of your 20. So very quickly, if you use that kind of phraseology and create a web of interdependencies between the claims, the cost could balloon in the United States, not the case in Canada. And significantly in Canada, we have an examination that you have to request in order to start the examination process. And the deadline for that is 4 years from the Canadian filing date. In the United States, examination is automatic, so you don't have to request it. Oftentimes, when we want to reduce the claim costs, when we're requesting examination in Canada, we file an amendment to reduce the number of claims, and that is the way that we save costs. In the United States, that amendment to reduce the number of claims needs to be filed when you're filing your non-provisional application. So I was speaking a little bit about request for examination deadlines already. We get, in the United States, you get a first office action, and then typically the next office action, if you haven't addressed all of the concerns, the examiner will make it final, meaning that to continue examination, you have to file a request for continued examination, or RCE. That's what's mentioned in point 6. However, in Canada, you get 3 office actions before you have to file an RCE. What is an RCE? It's basically just paying more money to continue the examination. In the United States, a major difference is that you can file what's called a continuation application. So let's say you're going through prosecution and you get a set of claims that the examiner is willing to allow, 20 claims allowed, and you want to take those claims, but you're not happy because you were forced during prosecution to add, I mentioned that there may be 5 elements and you had to add a 6th element. Maybe you had to add a 6th or 7th element in the claim in order to secure the examiner's approval of that claim. In the United States, you can take that approved claim and then file what's called a continuation. In other words, gives you another set of 20 claims, and you can pursue either a different invention or a different aspect of the same invention. In Canada, we don't have that practice. And so the continuation application is a very convenient tool in the United States in order to allow you to continue to pursuing more and more claims. Some important cases, we keep a continuation pending for the full life of the patent, particularly if there's expected litigation, as we can then amend the claims to overcome prior art that may arise, and it maybe invalidates previous patent applications, but our previous patents, but we can obtain new patents that are valid in view of that art. In Canada, we don't have that, and so we have divisional applications. And so what happens with a divisional application? Well, you can file a divisional application if you receive what's called a unity of invention objection. So in other words, this application, you paid 1 filing fee, but this application contains 2 or more inventions. And so we're going to force you to pay a 2nd filing fee for a divisional application to pursue invention number 2. And that's really kind of the basis of it, that, and also the idea that there is 1 patent for 1 invention. And so you cannot have multiple inventions in the same patent. But in both Canada and the US, we have this thing called obviousness double patenting. And so obviousness double patenting is a judicially created doctrine. It's not in statute. And it says that if your earlier applications are considered obvious, would render the current application obvious if disclosure in your, and often that's the case because the disclosures are identical. and there's something in the earlier application that would render the current application obvious, then they say, well, this is merely an attempt to double patent through the divisional, or in the United States, continuation process, a second patent to evergreen the patent. In other words, to push out the expiry date by filing serial patent applications that are really not different inventions. They're all kind of the same invention. They're obvious variations. And the origin of that judicially created doctrine was when we had a system that was 17 years from grant. So you could push out the expiry date because you had later and later grant dates. That all changed in 2000. In Canada's case, it changed in 89. In the United States, it changed in 2000, so that it's based on first to file system. So it doesn't matter. You can't evergreen a patent that way. They're all based on the filing date, is what the term, the expiry term is based on the filing date. All the continuations or divisional applications would expire at the same time, subject to patent term extension. So that whole thing is kind of meaningless, but the reason I bring it all up is in the United States, you can solve this problem by filing a thing called a terminal disclaimer. And the terminal disclaimer often really doesn't change the total expiry of the portfolio because it's all calculated 20 years from filing. But in Canada, we don't have that mechanism. And so that means that if you get an obviousness double patenting objection in Canada, it's fatal. The divisional falls. And what that means is that the only way to get a divisional application to stick is if it's a statutory divisional application that's filed in response to a unity of objection, a unity of invention objection, meaning that we want to provoke that unity of invention objection, if it's going to be raised at all, by including all of the independent claim types we might want in the original Canadian filing. And so that means that, in the US, you might say, I'm going to pursue the apparatus in claim 1, and I'm going to file a continuation to pursue the method. And I will get 20 claims for the apparatus, and I'll get 20 claims for the method. And those two cases are perfectly fine. In Canada, if you did that, you'd get an obviousness double patenting objection to the second case, and it would fall. So you would have to include the apparatus and method in the first case. And if the examiner doesn't like it, they issue a unity objection, and then we can file a divisional in response. So that's a fairly major difference, maybe at a practitioner level of detail that maybe not everybody is interested in, but for the practitioners in the audience, that's something that typically trips people up.
Robert and Mauricio, we do have 10 minutes left for the presentation, so we can have space for questions. So I'll just keep for the next slide, if that's okay.
Yeah, great. Do you want to talk about the accelerated examination, Mauricio?
Yes, sure. So with respect to accelerated examination, at the time of filing a patent application, we can pay for the request for examination, which typically speeds up when an examiner gets assigned to the application, rather than an examiner being assigned to the application within roughly 18 to 24 months. The examiner will be assigned within 12 months. So it's very advantageous to an inventor to have the accelerated examination available to them, especially once they're filing their application in the United States, when they commence their application, they file it first in the United States, and they have that option to have that accelerated examination. And as I said, it's very advantageous in that respect, because as an inventor, you want to be able to know rather sooner than later if your application holds water, meaning that if the application that you have or the invention that you have can proceed to grants within 12 months, because it's very important for an inventor or even practitioners that have clients in this position where, they may be on the fence if the application can proceed to granting, but to have this accelerated examination at their disposal is very important. And let me tell you why it's important. Because if an inventor has an idea, they want to file their idea, they want to protect their idea or their invention, I should say. they want to be able to have a budget in place to know that, if the application is going to be accepted in the United States or close to being granted in the United States, because once you file an application, based upon my experience in dealing with patents now for several years, is that no one application will get granted on the first go, on the first submission when you file your application. It's probably next to impossible, as Rob may know, based upon his experience as well. But you want to be able to know or put the client in the position where you can get the application as close to granting without having any, prior art discoveries later on that may trip the application. So having said this, you want to be able to put the inventor in a good line from the start, from the outset of the application, and request for that accelerated examination. So that way they know how to properly proceed later down the line. If it's an invention that they need to protect their invention in multiple countries, they can go down this route of having the accelerated examination available to them. So that way, if the application gets granted within the 12-month period, they're in a good position, because then they can file their application in various countries using what is called the patent prosecution highway. Once the application has been granted, we can go down the PPH route to have that accelerated examination placed in various countries that will then expedite their examination in other countries. So making the whole process more friendlier to their wallet, if you know what I'm saying. And also with respect to then, if they want to be able to extend time, they can then file the international PCT application, knowing that they have a strong priority document that has been granted or is going to be granted, and that they know that, that they then can proceed and file in other countries that will rely upon the first filed application that will be granted. So in that respect, it's very, very important to have that accelerated examination. And it's also very important to perhaps as an inventor or having a client in this respect to maybe first file their application in the United States in that respect. I don't know if Rob, you want to add something more to that?
No, just the only thing I'd add about the patent prosecution highway, or PPH, is that oftentimes we have found that filing a U.S. patent prosecution highway request on the back of a Canadian grant leads you to a faster and better result in examination than if you didn't do that. So there's a case to be made for doing advanced examination in Canada first and then going to the U.S. within the 1 year period, because your case in Canada will probably be allowed in under 6 months. And you can get patent prosecution highway in the U.S., and that often leads to the examiners allowing things more readily than if you didn't do that.
We have 5 minutes left before questions. So, Rob, why don't you talk a little bit about the specific considerations?
I mentioned already about obviousness double patenting and evergreening and all of that stuff. So I think what I'd like to add to that is about patent term adjustment and extension, because the whole purpose of obviousness double patenting is to prevent evergreening. But what we're trying to do, particularly in cases like pharmaceuticals, is where the development, the regulatory approval pathway may be 12 years, meaning that a lot of your patent term is eaten up before your product ever comes to market. So we're trying to extend term by strategically filing successive cases to different aspects of the invention that are patentable over the earlier disclosures. And so an element of obtaining advanced term is this patent term adjustment or extension concept. So it's very recent. In Canada, it just came in this year, January. And so in the United States, it's been around for a while. There's really two elements of it in the United States. There's what's called the Hatch-Waxman patent term adjustment, which compensates for delays in examination at the patent office delay. Subtracted from the patent office delay is applicant delay. So in order to get maximum patent term adjustment, you want to file responses quickly within the allowed deadline and not take extensions of time and that type of thing. And then You also have in the United States something called patent term extension, or PTE. Sounds very similar, but that is meant to compensate for regulatory delays by the FDA. In Canada, we just came up with this patent term adjustment system. Works based on patent office delay. Not the same calculation. The calculation is also complex but different than in the US, but it gives you additional days based on patent office delay. And Health Canada provides what's called a certificate of supplementary protection. So rather than extending the term of the patent, Health Canada has a separate thing which provides you with regulatory data exclusivity for a defined period of time for the first patent on the product. And that accomplishes something similar to the PTE in the United States. So, international filing strategy, I think, really there are two forks in the road. So you file this document which establishes a priority date. Maybe it's a provisional patent if you're a Canadian or American. Maybe it's a national patent if you're not. And at the 12-month deadline, you have a choice. You can go into individual countries via the Paris Convention, or you can file what's called a patent cooperation treaty application. Mauricio mentioned it. Provides you 30 or 31 months from the priority date to pick those individual countries. One of the things that's interesting about both of these options is restoration of priority. So what happens if you miss the deadline? If you want to file a Paris Convention application, the restoration of priority can be complicated. It's assessed country by country. And some countries have very strict requirements, others have less strict requirements. Under the PCT approach, there are, let's say, typically easier rules to satisfy. For example, in Canada, all one has to say is that failure to meet the 30-month deadline was unintentional, and pay an additional fee, and you have extended your period by a year from 30 months to 42 months. So the differences in the strategic choices you make will depend on whether you're before the deadline or after. And Mauricio mentioned the written opinion at the PCT level. So this is, you can file accelerated examination and try and get your patent granted early. And that gives you some certainty going forward with you're spending a lot of money to select a whole bunch of countries. Alternatively, an advantage of the PCT application is that a search is done and an opinion is provided as to what claims are patentable. And similarly, that gives the applicant some certainty in terms of saying, okay, here's the prior art that's likely to be cited. We think we can get a strong patent here, and we're willing to spend the money to go forward. Anything to add, Mauricio?
And no, I mean, you pretty summed it up pretty well. So that the written opinion is also very important because, as you mentioned, the claims, if they're allowable, we can then proceed via the PPH at that point in time in terms of entering with the national phases as well.
Right.
Yeah.
The last part would be about representation, and then we will have time for one question.
Yeah, I'll just briefly say that in the United States, you have to pass the USPTO patent bar to represent clients before the patent office. Typically, you're called a patent attorney at that stage. Typically, you've passed a bar exam in a state as well. And so you're able to do all things before both the courts and the patent office. In Canada, we have patent agents. Patent agents are regulated by the College of Patent and Trademark Agents rather than by the patent office. Even if you're a lawyer, you still have to pass the patent agent's exam or patent bar equivalent in Canada in order to practice before the patent office. And the patent agents have a very similar but separate regulatory pathway in Canada, not the same regulatory pathway as lawyers, which is the case in the United States.
Yeah, I can actually add something to it, but to actually be able and eligible to take the patent bar, you do need to have a technical background. So it's not just going to law school. You need to have some background inserted, usually in STEM. It's actually more broad than that, but you need to pay attention to this. I will stop sharing right now, and we actually have one question Let me see. Does the Canadian incomplete application receive a search report?
So yes, it does. It's published and it receives a search report. So it's basically very similar to a regular application. It just creates a whole bunch of line mines, because if you want to add subject matter to that, you're going to likely get objections. Whereas in the US, it's not examined, it's not published, and you can basically write a brand new application on the basis to file your non-provisional application. It may or may not be supported. The priority date and concepts in the provisional application may or may not be supported in the final non-provisional filing, but you can do that. And in Canada, you really can't. And so it goes through the regular process, gets examined, gets published, all that stuff.
We do have two more questions that I think would be great for the discussion. One that I think is everybody would ask it. How long does the patent process take until grant?
I mean, I can take that question. In the United States, it could take various years. It could take anywhere from, my experience, from 2 to 4 years, depending upon how many office actions are received and how complex the objections or rejections are from the examiner. So typically, it could take anywhere from 2 to 4 years to have the application granted.
And in Canada, it's basically 2 years following the filing of a request for examination, and you have 4 years to do that. So that can push the total out to 6. And the reason you might want to wait 4 years before requesting exam is to let prosecution settle in the other countries, so that you can then come to Canada with, say, a patent prosecution highway request and granted claims from somewhere else to expedite and save cost.
Yeah, that makes sense.
Another one here. What should you do if your country is not a PCT member?
Yeah, that's something I always get. Sorry, Rob. I will just answer this question. That's something I always get from clients that I receive, quotations from, which they're seeking from me. And they'll say, I have an international PCT application filed, but I want to enter, as an example, Argentina, Uruguay, or Paraguay. And at that stage, when I respond to them, they don't know that those countries are not PCT members. And they're kind of shocked to know that, they were misinformed at the onset of their application. So it's somewhat very important to gather as much information or reach out to as many people as you can in the patent community, or even us at Patentarea. Just send us just any question at all, just to help you in terms of how to start your process to get you on the right track from start to finish. So it's also very important to know that, and it's unfortunate as well when I do receive questions like this or inquiries from clients that I can't help them, because the time when it was obviously already lapsed from the first filing date. Already we're into the 30th month, and it's impossible to restore those priority rights in non-PCT member states.
Okay, we do have 1 minute left. So Robert, Mauricio, do you have any final remarks before we close for the day?
No, I think I'd just like to say that this was a varied audience, and so we went from, let's say, very, very broad to very, very granular. If there's something you'd like to know more about, feel free to reach out to any of us. We'd be happy to provide additional context and background. It's what we do and what we love.
Right.
Well, so thank you so much for our speakers, and thank you so much for the audience that was with us today, and have a great day.
Thank you.
Take care.
Bye-bye.
Bye-bye.